Michigan DUI lawyer coming to you today with actually something DUI related. Last week, I filed an application for leave to appeal in the Michigan Court of Appeals regarding search warrants. Now, if you are an attorney or if you've ever had a search warrant executed against your house, you know that a search warrant affidavit written out by police officers can usually be pretty lengthy. In a federal case or in a felony case, it's not unusual to see 35-page long affidavits written out by police officers that are extremely detailed, but also include page after page after page of stock language. Now, the stock language is actually important because it goes into the officer's training, qualifications, experience, and some of the things that a magistrate or a judge that's reviewing the search warrant affidavit does not necessarily know much about. Financial transactions, details regarding various types of illicit activities and that sort of thing. These are things that are contained in search warrant affidavits to ensure that general search warrants are not being issued in contradiction of the Fourth Amendment. Unfortunately, in drunk driving cases, DUI cases, search warrant affidavits are normally 1 to 2 pages long, and I can't emphasize this enough, they're very, very rudimentary. Here's an example of a search warrant affidavit that's created so that officers can quickly use checkboxes. Did the person pass or fail the HGN test? Did they pass or fail the one-leg stand? Did they pass or fail the walk and turn? And these things continue on regarding signs of consumption. Was there an odor of an alcoholic beverage? Did the person have bloodshot eyes, etc.? And the question becomes then, under the Fourth Amendment, just how many checkboxes do you need to check off before you've got probable cause? The problem with this is that it runs against everything that we know as attorneys about search warrant affidavits and how a judge or a magistrate that's reviewing a search warrant can't simply adopt whatever the affiant is claiming to be true as conclusory. They need to have evidence that they can draw their own inferences from. And hopefully, the Court of Appeals here in Michigan will grant me my application, allow us to argue the case, and we may see changes as we've seen in other states where checkbox affidavits are being stricken across the country.